Hey everyone, welcome to another video. So in this video, we'll try and understand a very important Supreme Court ruling which came out a couple of days back on event management services. Well, this ruling pertains to the case of Hindustan Times Media, HT Media versus the Union of India. This was not under the GST era, but under the pre-GST era. The petition in this particular case is HT Media, and this is how the transaction looks like. HT Media wanted to conduct a Hindustan Times Leadership Summit in India, for which it entered into agreements back then, pre-GST era, back then with US agents, with the sole intention of procuring, securing, and booking these foreign speakers who would come to India, who would coordinate with HT Media, come to India and attend the summit and speak. So the agreements entered into between HT Media and US agents were purely only for booking services and not for anything else. The intention was to find the speakers, book their dates, and then bring them to India to speak at this particular summit. Now, what happened was, on this particular transaction, initially the tax department back then, under service tax law, for the period October 2009 to March 2012, the period for which the services were rendered, said that the service given by US agents to HT Media. So HT Media entered into an agreement with US agents. So therefore the services provided by US agents from US to HT Media in India tantamounts to RCM, reverse charge mechanism, and you got to pay service tax in India. HT Media had to pay service tax in India. That's what the tax department said. This amounts to event management service, and therefore service tax will definitely be leviable on this particular service, is what the tax department said. To this, HT Media filed an appeal. It went to the CESTAT, that is a tribunal back then under service tax law. The CESTAT also ruled in favor of the tax department, which was unfavorable for HT Media. And then again, HT Media filed an appeal and went up to the Supreme Court. Now, at the Supreme Court hearing, which happened a couple of days back and the ruling was passed, the HT Media's contentions were as follows. One, the US agent is only a booking agent. The agreement entered into with the US agents was only for booking services, for securing speakers. It is not an event management service. They will not be organizing, planning, conducting the event as such. They'll only talk to the speakers, book their dates, inform HT Media, and then HT Media will have to plan, organize, conduct this entire summit happening in India. That is what the agreements clearly said. So HT Media's contentions or plea in this Supreme Court ruling was basically that, look, service tax under reverse charge is not applicable because it does not tantamount to event management service. It is only a booking service for securing speakers. There is no role of the US agents in conducting, planning, organizing this particular event in India. The Supreme Court heard the contentions of both sides, HT Media as well as the tax department, the revenue side, and passed a ruling a couple of days back where they agreed with the contentions of HT Media. That means they passed a ruling in favor of HT Media. And they said that yes, the agreements clearly say that the service is only for booking because they want to go and secure the foreign speakers. Participation in the event is not equal to management. There is no role of these US agents in management, planning, organizing the event. You cannot impose a strict interpretation and broadly classify this agency service as event management service and then get service tax to be levied on the same. So you cannot do a strict interpretation for this particular service and then broadly classify them into a service which is liable to service tax. That cannot be done. That is what the Supreme Court said in this particular case. Well, the takeaway from this is, what is the relevance in GST? Well, definitely, although the ruling came about a couple of days back, it pertained to the pre-GST era when service tax was applicable. But the takeaway or the bottom line here and what can be relevant for GST is basically that the principle of strict interpretation should be applied judiciously, should be applied logically. You cannot interpret a particular service and then say that it is categorized or subsumed into a broader category. agency or booking service is not equal to a event management service because there's no element of planning, organizing, conducting the event involved. So the takeaway here is, again, the principle of strict interpretation should be applied correctly, and you cannot subsume a particular service into a broader category. This becomes important when we talk about composite and mixed supplies in GST, because under GST, these two supplies are in the form of a bundle supply, and there could be interpretation issues whether this particular supply can be coming into a composite supply or a mixed supply, therefore being chargeable to GST. Whether GST is applicable or not is the second question. The first question is whether this is a particular service which can be classified into a broader category or not is the first question that is to be asked. So the ratio in the pre-GST era by the Supreme Court, the same ratio of the Supreme Court ruling can be used in the GST era, where questions of strict interpretation will come into picture. Well, I hope I was able to make things clear in this particular video. If you like the video, you could show support to us by hitting the like button. If you want more videos like these on a regular basis through the way of notifications, you could also think of hitting on the subscribe button. Till then, I'll see you guys in the next video. Take care and thank you.